Welcome. Good morning, good afternoon, wherever you might be joining us from. My name is Kevin Packman. I'm a partner in the Private Wealth Group in Miami. Joining me today are Andrea Cortés, a partner in the Corporate South Group out of Tampa, and Bill Shepard, a litigation partner out of West Palm Beach. Certainly feel free to check our bios if you'd like online. We've got a lot of information to get through, so we're going to sort of bypass that. When we came up with the topic today, really it was because there's always issues going on with the IRS. And Andrea and I do a great deal of compliance work. And we always have clients asking us, well, how are they going to find out if I'm non-compliant? Or if they're in the system, how are they going to collect from me? Or if they're living abroad, how are they going to collect from me? And always the favorite one is, can I be extradited? And so that was kind of what we wanted to address today. And then out of nowhere, we get the Biden administration in their introduction of the American Families Plan, where they're saying that they're going to have $80 billion, or 80 million rather, sorry, that they're going to allocate towards the IRS for increased audits and enforcement. And so even more important now to really understand the tools the IRS has to find you and collect from you. And it's not just limited to US taxpayers. Many of these same approaches are available to the IRS to help foreign jurisdictions seeking information on their residents from the US. So with that, I'll kick it over to Andrea to get us started.
All right, thanks, Kevin. I'm going to start off with IRS enforcement tools, how the IRS obtains information on non-compliant US taxpayers. And this is information that they get from the taxpayers themselves. So one of the most common ways that the IRS obtains information is through Form 4564, the Information Document Request, or IDR, and that's issued by an agent during a routine audit. Code section 7601 gives the IRS pretty expansive authority to request basically any kind of information that the IRS agent requires to resolve the audit. So depending on the nature, that could be, bank account records, credit card records, canceled checks, basically anything to try to get at income, deductions, or possibly the existence of foreign assets. And I think, depending on how the taxpayer and their representatives respond to that IDR, maybe the IRS agent wraps up the audit upon receipt of the information, or it can continue to issue additional IDRs until they get the information they feel helps them resolve that audit. So it's important, I think, to realize or to be aware that IDRs are not necessarily enforceable. But if a taxpayer fails to comply with an IDR, then the IRS will likely proceed with issuing a delinquency notice. And if the taxpayer, continues not to comply, ultimately, the agent can get an Irs summons to try to enforce compliance. So I think that that goes easily into our next topic, which is the Irs summons, and that under Code Section 7602, the IRS has the power to compel a taxpayer to either appear or provide information. There are some checks or limits on the IRS's authority. Those are called the Powell requirements. That stems from a 1964 case. But basically, the inquiry has to be based on a legitimate purpose. So the IRS can't be, unfairly harassing the taxpayer. The inquiry has to be relevant to the specific purpose. So the agent can't be using a summons to unearth information that's related to another matter or even another taxpayer. The IRS has to follow certain summons procedures as laid out in the code. And the IRS can't be requesting information that they can get from another source. From the taxpayer side, the taxpayer can't use the fact that the information is located outside the US as an excuse to not comply. If the taxpayer fails to substantially comply with the summons, then a civil court order could be obtained to enforce compliance. If the taxpayer continues to refuse to comply, then ultimately the taxpayer could be held in contempt or even criminally prosecuted. Yet another way for the IRS to obtain information is via one of the many administrative programs. So the voluntary disclosures, which have been around for years, the streamlined foreign or streamlined domestic offshore procedures, and also the updated voluntary disclosure practice. So through these administrative programs, taxpayers are required to provide information to the IRS in exchange for reduced or even eliminated penalties in some cases. So I don't know the exact numbers to date, but I recall that from about 2009 through 2018, there were about 60,000 voluntary disclosures and another 65,000 or so streamlined disclosures. And I know, we continue to get a pretty steady stream of these kinds of matters coming in. So through these disclosure matters, taxpayers have to provide very detailed information on their banking activities and their dealings with their foreign advisors and other fiduciaries. So the IRS has all of that information to follow up on. Kevin, I will turn it over to you to discuss the next topic.
Perfect, thank you. So it seems somewhat intuitive, but the IRS also gets information from taxpayers based on the forms that they do file. For example, the FBAR, if you have a joint account, on the FBAR, you are reflecting who you own that joint account with. It could be 1, 2, 3 people, and you're providing that information to the IRS. So if I have a joint account with Andrea, we're not married. I report my account. She doesn't report hers. The IRS now has that information to try to match up somehow in their computer systems and then start audits and do whatever the heck they want to do with the information. The Form 5471, for anyone not familiar, is a form filed to reflect connections to foreign corporations. There is a part of the Form 5471, it's Schedule B, where you have to list all U.S. shareholders. So again, if I'm reporting it, but the other U.S. shareholders are not, the IRS now has that information. The Form 8854, interestingly, this isn't one where they get information that is helpful against someone else, but it's sort of what happens when things go wrong. You file the Form 8854 if you're going to expatriate. And there's 3 real cases, recent cases of, let's just call it expatriations gone bad. Gerd Topsnick was a German national who was a long-term green card holder. And he left the US, didn't file the appropriate forms to signify that he was renouncing or giving back his green card, and entered into an installment agreement, got a lot of money. Well, lo and behold, because he didn't do the right things, he was still taxed on the installment proceeds in the US. Moreover, because he hadn't filed the 8854, when he finally got around to doing it, the remaining installment agreements were part of the exit tax. So he got a double whammy from not doing the appropriate things. On the other hand, we've got Dan Horsky. Not really sure what he was thinking, and that's why he's in jail. But Horsky was a business professor for 30-some years in New York, and he had a number of investments offshore. Most of them didn't do well, but by and large, one did do really well. And rather than report and do the things in the US that he was required to do, he got a nominee to take ownership of all of his assets. And then a Swiss bank helped that nominee expatriate by filing the 8854. Because the assets were still Horsky's, clearly he didn't avoid anything. And once the IRS found out, as I said, he went to jail, but he paid a $100 million FBAR penalty and about $13 million in tax. And then on the other side, we've got Oleg Tinkov. This is a 2020 case where he was indicted. He hasn't pled guilty yet, hasn't gone to jail. We don't know how it'll end up, but he was a Russian founder of an online bank. That bank went public on the London IPO in 2013. 3 days after the IPO, he decided to expatriate. He filed the 8854. The problem for him is he failed to reflect that he happened to own $1 billion worth of stock through a BVI entity. And so that didn't go over real well either. The key piece being here, the IRS has a number of ways to get information on US taxpayers who are not doing the right things. And with that, we will turn to enforcement tools. And the first enforcement tool that is really out there that's available are income tax treaties. And the importance or interesting aspect of income tax treaties is that they work both ways. Clearly, I think everybody would be aware of the fact that, you know, an income tax treaty is generally helpful to avoid double taxation. But income tax treaties do more than that. Income tax treaties also have an information exchange provision in them. It's usually, I think it's Article 26, if I'm not mistaken. And Article 26 will provide how that the two jurisdictions through the competent authority will share the information back and forth. There is an automatic exchange, and automatic being what it sounds like. There's exchanging upon request, where one country asks the other country to provide information, and then there's spontaneous, where one government unilaterally sends information to the other government on the theory that what they have is helpful. And as I said, the information works both ways. The fact that we have these treaties, and we have somewhere, I think it's like 70 treaties, any of those countries can come to the US and ask the US to help them get information. And some examples of those, right now, I'm actually dealing with two Canadian nationals who are resident of Australia. They received a summons that was sent to one of their US addresses. And what it really turns out is they were under examination in Canada. They weren't aware of the fact that they were under examination in Canada. And the Canadian authorities requested the assistance in serving a summons on the Royal Bank of Canada in the US. And so the taxpayers were really just getting notice, because when these things, a summons are issued, or a levy on a third party, the taxpayer gets information. They have the ability to try to contest or quash if it's a summons. In this instance, again, taxpayers didn't know, so they will probably be obtaining or hiring Canadian counsel to help them on the Canadian front. Several years ago, I had a US taxpayer who got an IDR, and the IDR was issued through a treaty from India. And the Indian authorities thought that this individual had an Indian tax liability. Turned out he did not. The interesting part also, when these exchanges come, often it can take a long period of time before it gets to, at least in the US perspective, a foreign government asks through the competent authorities, comes to the US, it could be many years later. And the request doesn't change, it's still for the same tax periods, but the statutes of limitation here may have already closed. And the agents, at least that I've dealt with in the IRS, recognize that. They say, well, just write back and let us know that this information is not available, or you don't have it, or the statute's closed. They don't seem to exercise the same degree of interest, shall I say, in pursuing IDR enforcement when it's through one of these treaties. At least that's been my personal experience. Then we go right into John Doe. John Doe's been in the news a lot lately. Perhaps you're familiar with it, but John Doe summons is authorized by 7609 subsection F of the Internal Revenue Code. And it allows the IRS to obtain information on a group of taxpayers when it doesn't have their identity. The summons is authorized by a federal court, and the IRS needs to demonstrate that there's a reasonable basis that this group of taxpayers have non-compliance, and the information isn't otherwise available. Similar to the other issues and treaties, John Does can be used domestically and internationally. And when it's done domestically, it can be done to help a foreign government. Two examples where that has happened. In 2013, 18 US financial institutions received John Doe summons seeking the identities of persons who used debit or credit cards from those institutions. This stemmed from a request from Norway. Norway believed that there were a number of Norwegians avoiding tax by using these cards tied to US institutions. A separate summons was actually issued to Prairie Bank in Minnesota because the Norwegian authorities had the debit card number for a specific individual, and they wanted to know who that debit card was tied to. So while that was 2013, more recently in 2019, John Doe summons were issued to several financial institutions seeking information for the tax period 2013 through 2017. And this request came from Finland through the treaty network. And Finland had advised IRS that when a debit card connected to a foreign financial institution was used in an ATM in Finland, all they was required was a PIN, and they had no information on how to identify those individuals using the debit cards or ATM cards. So they asked the IRS to go to these institutions where the debit cards were issued to get information that could be provided. And with that, then I kick it back to you, Andrea.
All right, cryptocurrency seems to be a hot topic lately. The IRS is actively going after taxpayers who have failed to report income in connection with crypto transactions. And we now have Operation Hidden Treasure. That's a collaboration with the IRS Criminal Investigation Division and the Fraud Enforcement Office. And they're trying to find taxpayers with unreported income from virtual currency transactions. And I know at least in the last couple of months, there have been at least 2 John Doe summons issued to virtual currency exchanges, Kraken and Circle. And the request is for information on US taxpayers who have at least $20,000 of virtual currency transactions from 2016 through 2020. So again, the IRS is really focusing in on lots of these cryptocurrency transactions. Kevin?
So we will actually have a webinar later this fall for anyone interested in the next matter I'm going to discuss. In December 2020, a John Doe summons was issued to an estate planning law firm in Texas, Taylor Lohmeyer, and it was appealed, blah, blah, blah. Essentially, it was sustained at the en banc level of the circuit court, and they allowed the John Doe summons to be issued to the law firm. Apparently, the law firm had helped one client in particular open 5 foreign accounts and form 8 foreign entities. The IRS claimed that the law firm helped the client structure their affairs so that the income that they were earning was assigned to these foreign accounts. Turned out that between 1995 and 2009, the taxpayer avoided that's what's called a significant amount of tax. In the 4-year period, 1996 through 2000, they had unreported income in excess of $5 million that resulted in more than $2 million. And in all, they paid $4 million in tax, interest, and penalties. That's at the taxpayer level. But again, all we care about here is the John Doe summons and what was done at the law firm level. The IRS was requesting information over a 12-year period ending 2008, the names of all clients who used the firm to, quote, acquire, establish, maintain, operate, or control any foreign financial account or other asset, any foreign corporation, company, trust, foundation, or other legal entity, or any foreign or domestic financial account or other asset in the name of such foreign entity. In general, the names of clients are not subject to the attorney-client privilege. But when information related to certain non-compliance essentially leads back, then you could have a situation where it is. So the summons also sought the names of all persons acting as advisors and the names of all persons acting as clients on the subject matter covered by the document. We're not going to get today into more discussion on this, other than to note that if the IRS is able to issue John Doe summons to law firms And the attorney-client privilege is not a defense to that John Doe summons. It really questions where and how things are going to end up in the future as it relates to IRS enforcement. And I kick it back to you, Andrea.
All right. Foreign banks. So as probably most individuals may know on this webinar, it was a John Doe summons that really blew the lid off of Swiss bank secrecy back in 2008, when a judge allowed the IRS to serve a John Doe summons on, Swiss megabank UBS AG for information on U.S. taxpayers that had Swiss accounts. And I think, an interesting point to that is that UBS could not just comply with the summons without violating Swiss law. And so ultimately, the US and Switzerland had to come to an agreement. They signed a protocol to their treaty to allow for the disclosure of, it ended up being 4,450 account holders who had tax fraud or the like, were the buzzwords. And what did that mean? That was interpreted to be account holders who either held their accounts through a structure, so corporation or a trust or foundation or something like that, or they had an account balance in excess of $1 million and also did not have a Form W-9 on file with the bank. So I think that's one popular example. The IRS has also issued John Doe summons to HSBC in India. And after the initial John Doe summons on UBS, a few years after that, the IRS had obtained another summons against UBS to try and track the flow of funds that went from UBS to Beglin and other Swiss banks. So it's another good way for the IRS to get a lot of information on US taxpayers.
Jump in for one more issue. John Doe summons have also been issued over the years to PayPal, to MasterCard, to American Express, name it, it's been done or will be done in the future. So the IRS is not shy about who it issues John Doe summons to for its own purposes.
Let's jump into the next bullet point, intergovernmental agreements or IGAs. This is another enforcement tool. The US has collaborated with other governments to develop 2 model IGAs that are used to implement FATCA. FATCA is the Foreign Account Tax Compliance Act. It was enacted back in 2010, and it requires foreign financial institutions to report to the IRS on accounts held by US persons. And if they fail to do that, they are subject to a 30% withholding tax on US sourced payments. So given there are many global financial institutions that hold US stocks, investments, being subject to a 30% withholding tax is significant. And so as a result, you had many foreign governments agreeing to enter into these IGAs to comply with the FATCA disclosure requirements. So under both model agreements, the premise is that the foreign partner government will require its foreign financial institutions to report or identify US accounts and transmit certain information to the US taxing authorities. So what kind of information is reported? It's the account holders' names and addresses, account numbers, and also the highest daily account value in the foreign accounts. Now, I mentioned there were 2 agreements. Model 1 is the most common agreement. And under the Model 1 IGA, the foreign financial institutions transmit data on the US accounts to their own tax authority, the foreign tax authorities. And then the foreign tax authorities transmit that data to the US tax authorities. There are also many reciprocal Model 1 IGAs. So in return, then the US tax authorities do also agree to transmit information to the foreign taxing authorities on their taxpayers. The Model 2 IGA is less common, more simplified, but there are only a handful of countries that have entered into a Model 2 IGA. And under that agreement, the foreign financial institutions have agreed just to transmit information on US accounts directly to the US taxing authorities rather than going through their own home country taxing authorities. Another way that the IRS obtained information is through the Swiss Bank program that was introduced in August of 2013. And that was sort of like a voluntary disclosure for Swiss banks. It was a mechanism for the Swiss banks to avoid criminal liabilities in exchange for transmitting certain information on their US account holders. So there were 4 different categories of banks. I think in the interest of time, I'll probably just zone in on category 2 that had the most participating. So 80 banks participated as category 2. And that was for banks that had reason to believe that they had engaged in tax-related offenses. They requested a non-prosecution agreement, and in exchange, they had to give the US authorities lots of very detailed information and also pay penalties. So the information included kind of a information on not including the account holder's identity, but other detailed information on accounts for which US persons had either direct or indirect interests. They also provided detailed information on all of the inflows and outflows, all of the transfers going in and out of those accounts, and also information on the bank's procedures for how they dealt with US account holders. And finally, those banks, category 2 banks, had to agree to close the accounts of any recalcitrant US account holders. So those account holders that didn't want to come forward. I mentioned that they had to pay penalties. The penalties were equal to, between 20 to 50% of the maximum aggregate value of all the US related accounts. Now, the penalty could be reduced if the banks convinced some of their US account holders to come forward and disclose their accounts. So you did have, at the time, I recall a lot of Swiss banks even funding the legal expenses for the US account holders to try to get those folks to come forward so that they could reduce their penalties under the program. Again, lots of information came over to the IRS, and those banks also have an ongoing requirement to continue to cooperate. So they continue to cooperate and provide information. There has been some discussion as to whether or not, since that program was so successful, whether the IRS DOJ would replicate that program in other jurisdictions, but we've not really seen that happen on any large scale. Kevin, I will turn it over to you.
Moving into whistleblowers and how again, continuing with the theory of how IRS gets information from third parties. Many individuals are familiar with whistleblowers and the concept of whistleblowing. The IRS has a whistleblower office, and if taxpayer sends information to the IRS on another individual, and it turns out they're able to collect from that individual, the whistleblower can get paid a reward. And between 2007 and 2020, the IRS whistleblower office has collected more than $5.9 billion, and they've paid out more than $1 billion in rewards. Many people have some knowledge or familiarity with the name Bradley Birkenfeld, and he's the whistleblower from UBS, who ultimately the information he provided the IRS is what led to the very first 2009 offshore voluntary disclosure program. But he was not actually the first whistleblower in, let's call it, more recent days, and it relates to tax. In the early 2000s, there was a data processor by the name of Heinrich Kieber, and he worked for LGT Bank in Liechtenstein. He was doing microfiche film or whatever the heck he does as data processor, and noticed things that to him seemed peculiar. So he copied all this data and sold it to many governments, one being Germany. The US claims they'd never paid for that information, but there were many US taxpayers who ended up under audit. This is pre-UBS, and at that time the IRS introduced these IDRs that were 20-some pages. They'd include the kitchen sink. It was everything under the sun. And so that helped them in many ways get ready for when they got the information from UBS, because they were already aware of what sort of things they could and should ask for. So we go from Kieber to Bradley Birkenfeld in 2007. Then there's a different kind of whistleblower, not the ones going to the IRS seeking to get a reward. It's the individuals who, possibly out of altruistic measures, think that sharing information with the public at large is some public benefit. And those individuals often work in conjunction with the International Consortium of Journalists. And the first time we really heard about this group was in April 2016 with the Panama Papers. And what that was the release of 11.5 million financial records from the Panamanian law firm of Mossack Fonseca. These records covered the time period 1970 through 2015. The very next year, November 2017, we had the Paradise Papers that many people may not be familiar with. That was when more than 13.4 financial and confidential records, mostly from institutions in the Caribbean, were released. 6.8 million documents came from the law firm of Appleby and Astera, which was an offshore provider. More than 6 million came from other corporate providers in the Caribbean, and a smaller amount came from, I don't know how you pronounce it, Asiati Trust in Singapore. Then a couple of years later, so that we have September last year, we had the BuzzFeed release. If you're not familiar with that, BuzzFeed shared information on SARs, which are suspicious activity reports filed with FinCEN. FinCEN is an institution of the US government. FinCEN is where FBARs are filed. You would think that there'd be great security on these records, but 2,100 SARs were, let me take a step back. They got a whole host of information, but from 2,100 SARs, they were able to identify $2 trillion worth of transactions that were moving through the world economy. These transactions are deemed to be questionable, which is why a SARs is filed in the first place. And from those, they were able to identify specifically 18,000, a little bit more than 18,000 transactions that had $35 billion worth of transactions from 2000 to 2017 that were flagged by financial institutions. Personally, I always wonder and question how the data can be taken from these institutions and nobody's prosecuted. At the end of the day, that still is stealing, whether it's in the public good or not, but that's where we are now. We have whistleblowers going to the IRS, and then we have whistleblowers who basically get information from institutions, share it with this group of international journalists, and then it's shared all over the internet. Many, many of these individuals that are using these offshore providers have been found to have non-compliance in the US and other institutions. Many have been found to be involved in criminal transactions. But the truth of the matter is not everybody who's doing business offshore is a criminal. And having foreign accounts, foreign entities doing business is not illegal. If it was, the IRS wouldn't have the forms that tell you to report it. It'd be illegal. There would be no forms. So that's the whistleblower program. Then we go to the MLATs, Mutual Legal Assistance Treaties. We have, give or take, 70 MLATs. And MLATs are traditionally thought of as being used in a criminal context. And that's where one government exchanges information to another government to help it enforce its criminal laws. They're generally not used in tax cases, but they can be used. While we have 70 of these, we include every one of the EU countries. There's no requirement that the criminality exist in both jurisdictions. So if country A goes to the US through the MLAT process and says, we need information on ABC, which is a crime here in country A, but it's not a crime in the US, doesn't matter, the MLAT is still processed because you don't need dual criminality. In contrast to everything dealing with the IRS, really, on the treaty requests, IDRs, summons, levies, liens, there is no requirement to share the information with the individual that an MLAT process is underway. So taxpayers don't have an opportunity to challenge it. Interestingly, maybe not interestingly, I've had a number of clients over the years, traditionally from Brazil for whatever reason, who move to the US and want to find out if there's anything that can happen to them in the US for tax issues they have in Brazil. And we will go through all of the numerous processes that governments have to work together. But at the end of the day, whatever they had done wrong in Brazil did not rise to the level of a crime in Brazil. And as such, an MLAT would not work. We don't have a TIA with Brazil, Tax Information Exchange Agreement that we'll get to next. We don't have an income tax treaty with Brazil. So in that instance, if there is no crime in the foreign jurisdiction, again, an MLAT is not going to be available. Because the MLAT process can take many, many years working through the bureaucracy of going through your own home country, then to the US, or if the US is issuing it externally before it goes through the processes to get to the foreign government, can take many, many years. So a couple interesting things from that purpose. There is a way that the statute of limitations in the US can be suspended until the MLAT process runs through the cycle, so that the government doesn't lose the ability to prosecute the US individual who's done something bad with the useful information they get from abroad. But again, because it takes so long, in 2018, we have something called the Cloud Act that was created, and this enables governments to work in real time to share electronic data and evidence that would be useful in the criminal context. Moving right along to TIAs, Tax Information Exchange Agreements. These are solely based on sharing information for tax purposes. And we have them with countries with whom we don't have an income tax treaty. The number of jurisdictions with whom we have TIAs, or those countries include Argentina, the Cayman Islands, Costa Rica, Guernsey, Hong Kong, the Isle of Man, Jersey, Panama, and Singapore. So, notwithstanding not having a treaty, we have these agreements with many countries that we're working together to share information. This might be information that doesn't come through FATCA and the IGA process. That moves us into Irs Campaigns.
Thank you. Irs Campaigns, the IRS Large Business and International Group started campaigns in 2017, and these are issue-based audit strategies that try and target issues that have kind of a high risk of non-compliance. So cryptocurrency comes to mind, captive insurance, there are others. There has been a total of, I think, 68 campaigns issued. About 57 are still active, and a number of those focus on high net wealth individuals, the expatriations, people that have gone through voluntary disclosures, so the post-compliance period, OVDP declines or withdrawals. And so through those audits, the IRS obtains, again, additional information on these non-compliant taxpayers. I see that we're running short on time. We want to cover all of our other topics. So I'm going to jump into statute of limitations. This is, maybe viewed as a defense to some of these enforcement tools. So the IRS generally has 3 years from the filing of a return to assess the tax. And then there's some exceptions to that. So one of the common exceptions is for substantial omission of income. If the taxpayer omits more than 25% of gross income, then the statute of limitations is extended to 6 years. There's also a 6-year statute of limitations for failure to report more than $5,000 of income that relates to a foreign financial asset. And also an important exception is for the failure to file certain information returns, foreign information returns. Under section 6501C8, the statute's extended for 3 years after the date that all the required foreign information returns are filed. And the interesting part of that is that that statute remains open for all items on the tax return. That was from March, I think, of 2010 forward. So not just the information, the foreign related information, but all items on the tax return. We did have, one more very important one is the statute remains open indefinitely for a taxpayer that has either filed a fraudulent return or not filed any returns. So we had one question that I saw that I do want to just touch on real quickly. The question is, what are your thoughts when the IRS or state taxing authority asks to extend the statute of limitations when they're doing an audit? In my experience, if the IRS is paying attention to the statute of limitations, there's really no way around extending it because the IRS will just assess the tax. So I don't know, Kevin, if you have any other thoughts on that one before we move on.
Again, it really depends on the very specific facts of the case, because if the taxpayer, is scared of, criminal exposure, maybe, then there's strategic reasons why you may or may not want to extend a statute. But I think it's a general rule on a civil examination. It's important to extend a statute if you want to have the ability for the taxpayer to get to appeals, because there has to be a certain period of time left on the statute in order for the taxpayer to get to appeals.
Great. I know there are some other questions that have come in, but we may need to defer those towards the end of the presentation, or even follow up afterwards to give enough time to cover collection. So we're going to switch gears a little bit and run through some IRS collection tools. And this is important in particular for, how does the IRS reach assets that are offshore? So one of the main collection tools, which is, for domestic or offshore assets, is the federal tax lien. A tax lien is a government's legal claim against a taxpayer's property. So how it works, the IRS assesses the liability. Within 60 days, they send the taxpayer a bill. That's going to be your notice and demand for payment. If the taxpayer fails to pay, then the IRS can file the notice of federal tax lien, and that alerts creditors that the IRS has gotten interest in the taxpayer's property. So I think collecting, on U.S. assets obviously is a little bit easier because the IRS does not have express statutory authority to take collection action against foreign situs asset. You either have to have a collection assistance treaty, or the IRS has to pursue judicial collection remedies. And oftentimes courts in other countries don't necessarily want to be willing to collect taxes for another that benefit another country. So Kevin, that's kind of a nice intro into your next topic.
Well, staying with the issue of liens for an individual who's not U.S., very real issue. Many accountants will use their address for a taxpayer, especially a taxpayer who lives outside the U.S. There's nothing wrong in doing so, but you may run into a situation that we're dealing with right now. Taxpayer was in the original 2009 Voluntary Disclosure Program. He had a green card. IRS lost his file. Maybe 2013 IRS popped up and wanted to start working through the voluntary disclosure. By that time, the taxpayer had essentially sold all of his assets. He was closing up business. He was, an older guy. Moved back to Brazil and had, for estate planning purposes in Brazil, given a lot of his assets to his children who were Brazilian. Well, now here we are many years later. IRS has assessed, I think it was about $1.6 or $1.7 million in total. And they're filing liens, but they're using the accountant's address because the taxpayer doesn't have anything in the US. They thought that was the taxpayer's address because that's what's reflected on the tax returns. Taxpayer doesn't have any US assets. So the ability for the US to collect will essentially be limited, most likely to Social Security income that's distributed. So again, keeping in mind that these provisions all apply to foreigners as well. And in the context of the US trying to collect, really there's not a lot that can happen if they're in a jurisdiction. Panama, I've had clients go to Panama, I've had clients go to Israel. If they're going to leave and figure that the IRS can't get me here, nothing stops them from doing so. They, will get into problems they may have that aren't tax driven. But what can the IRS do when it wants to collect from a foreign jurisdiction? We have a grand total of, I think, was that 6 treaties that have collection provisions in them. That's Canada, it's France, Denmark, Sweden, the Netherlands, and the UK. That allows a foreign jurisdiction to come to the US and say, please collect out of the US assets of taxpayer ABC, whatever, because they owe us tax here in France. I have had 2 different issues involving France. I don't know how the French tax authorities work, but in both instances, these taxpayers had no knowledge that there was anything happening in France. And so we got French counsel involved to help them. The issues eventually went away. But it's very real and very concerning when an individual gets an IDR from IRS saying, here we're collecting or seeking information from country XYZ. And when it's a collection issue, obviously it's much more, it's much scarier, shall I say, than in a strictly information setting. I skipped over Convention on Mutual Assistance in Tax Matters. We have these agreements as well. There's many many jurisdictions around the world that are parties to this, and that also has collection provisions that require each jurisdiction to help the other. We're on to levies.
Yep. The levy of a domestic branch of a foreign financial institution. So whereas a lien sort of secures the government's interest, the levy takes the property, seizes the property. So if a taxpayer does not pay, the IRS can levy and seize any property that the taxpayer has an interest in. And so interestingly enough, that can include property in an offshore bank account if the offshore bank has a branch in the US or the US possession. So there are some detailed procedures that the IRS has to follow in Code Section 6332 and the related regulations. But basically, the IRS can simply issue a levy notice to a US branch and have the ability ultimately to take possession of the funds in the foreign financial account. I want to give enough time to Bill Shepard to talk about extradition. So I'll turn it back to you, Kevin, for the FAST Act.
Yeah, so the FAST Act was introduced by Section 7345, maybe, I don't even remember, maybe 10 years ago. And it authorizes IRS to certify a taxpayer's seriously delinquent tax debt to the Secretary of State. That then enables the Secretary of State to revoke a passport, to deny the renewal of a passport, or to deny the passport application altogether, or the renewal, and I said as a revoke. The IRS must have placed a lien or a levy, and seriously, the amount that's considered to be a serious debt is for 2021, $54,000. However, if the taxpayer is involved in appeals or trying to work on making payment, offering compromise status to collectability and installment agreement, then this doesn't happen. It only happens when the taxpayer isn't doing anything and the debt is out there with a lien or levy. Since 2019, IRS has collected $1.2 billion through the FAST Act processes.
So I'm going to cover a couple of, well, maybe just one of the 2. There are 2 types of orders that the IRS can implement for non-compliant US taxpayers that are intending to leave the US. The first one is the Ritne Exeat Republica, if I'm pronouncing that correctly. That in Latin translates into "let him not leave the Republic." That's an order that it's authorized under Code Section 7402A, and it generally prevents someone from leaving the US if necessary to enforce our tax laws. So there's one somewhat recent example of that. And actually, it was a situation where the taxpayers had already left the country but came back. It was a Colorado couple, the Barretts, Kathleen and Charles, and they claimed that they filed a fraudulent tax return, but they blamed it on their tax preparer, said they never signed the returns, and as a result, they got a tax refund. So the IRS catches up with them. they end up ultimately filing an amended returns, but they keep the refund. And so ultimately the IRS, goes to court, obtains a default judgment against the taxpayers. And so, rather than pay, the taxpayers decide to liquidate all their US assets and move to Ecuador, and, kind of forget about the issue. In the meantime, the IRS goes to court and obtains one of these orders. And so several years later, the Barretts come back to the United States to attend their daughter's wedding. And when they get to the airport to leave again for Ecuador, they ended up getting arrested. So it actually is an order that works. The customs order, prevent departure order, just real quickly, is very similar, but it can prevent a non-US citizen from exiting the US pending resolution of a collection matter.
As it relates to collections, Andrea already talked about the statute for assessment purposes. Once there is an assessment, the IRS has 10 years from the date of assessment to collect the tax. Interestingly, though, Code Section 6503 sub C permits the IRS to suspend the collection statute if a taxpayer is continuously outside the US for 6 years. So that's an interesting little detail to consider. And with that, we will turn it over to Bill to discuss how extradition works, what exactly it is, can it work for tax, and really anything else he feels like talking about in the next 7-8 minutes.
Great. Well, excuse me. Thank you, Kevin and Andrea. I mean, this is, you've covered a lot of territory, but I think one of the things that people should really take away from that first section is there is a tremendous amount of information and data that is changing hands between governments all around the world. And as the couple who came back for their daughter's wedding can tell you, there really is no place that's safe if you are not bound and determined to live in a tax extradition status for the rest of your life. The way extradition works, just in general, big picture, is that the United States has treaties with countries all around the world and works through a global body called Interpol. Interpol is based in Lyon, France. Actually in a beautiful park like Central Park in New York. And Interpol has senior law enforcement executives from around the world who go and trade information back and forth. If a government is seeking extradition of a defendant or potential defendant in a criminal case, they work through Interpol to issue what's called a red notice. A red notice goes through an internal process, and if counsel is engaged early, you can challenge that red notice process because there are certain regions in the world or countries at play where sometimes those are really driven by political decisions against former political adversaries. And Interpol's sort of reason for being, in addition to exchanging information, is also to sort of act as a vetting tool so that political vendettas can't infiltrate their way into international law enforcement. So there's an opportunity there to attack the red notice. But if the red notice is out and in existence, there are 182 member countries of Interpol at my last check. Most of the places you'd want to go are members of Interpol. If you change cross borders, that red notice is going to kick up. Now, when you're talking about a tax circumstance, there are lots of countries where the tax penalty is not viewed as a criminal penalty, but as a civil penalty. And that's one of the things Kevin was talking about earlier when he talked about MLATs not requiring dual criminality. It's a crime in country A and in country B. But for extradition, it has to be a crime in both places. Otherwise, the United States will not be able to extradite that potential defendant into the United States. So the quick trick around that is if it's not just a tax crime that the subject is being targeted for, but say there's some money laundering components to it. Say that in country A, where the person resides, it is a crime to lie on a government form, to make a false statement to the government. Well, the United States has a similar crime. there are a host of ways that should this particular person rise high enough onto the extradition sort of target list, that the person's background can be investigated and looked at to see if there are other crimes that have been committed. Now, if extradition is successful and an arrest is made, or I should say a request for extradition is successful, and an arrest is made in the foreign jurisdiction, well, the person's entitled to challenge it there. So Kevin and I have worked with clients who were facing extradition from foreign countries and litigated heavily in the foreign jurisdiction before any extradition process was really sort of engaged in a very aggressive way. I'm involved in a matter right now where the co-defendant is fighting extradition, has gone all the way up to the Supreme Court of that country, has now made a petition to the State Department equivalent of that country, and then can ultimately make a petition to the Prime Minister of that country. All of that has to happen before extradition can occur. That is a lengthy process and one that has a number of off-ramps. But if extradition is successful, and let's put aside the pure tax crime piece, even though I realize that's what we're talking about in a general sense, I think extraditions of people who have tax problems are much more likely to be in this alternate category where it's not a pure tax issue. So then the person comes to the United States and faces their criminal prosecution. One of the grounds to attack that criminal prosecution is that the prosecution is extending beyond what the actual terms of the extradition were for. So in other words, if you're in country A and they agree to extradite you for crimes A, B, and C, you can't arrive in the United States and have the Justice Department decide, well, we're going to tack on crimes D, E, and F. You can only be prosecuted for the crimes that you were extradited to face. Dual criminality is really the crux of the challenge in most tax circumstances, because as we mentioned earlier, there are a lot of countries in the world where there's not a dual criminality provision to this. But also the other piece to think about when you're thinking about extradition, it's a political process as well, as much as it is a legal process. And so it's an issue that hinges in large part on what's the relationship between the US government and the target government. Or if you're not a US taxpayer, but you're living in the US and you're facing extradition to your home country where you may have tax issues or other issues. Kevin and I were involved in an issue involving a type of tax in India, and representing clients here in the United States who were trying to focus on some of the issues related to that. It's the same process and challenge, you're just on the other side of the equation. And so extradition can go both ways, but part of that and part of what can really happen in those circumstances is as there is shift in political leadership in foreign countries, there is sometimes shift in US analysis or US position, and an opportunity also to go back to Interpol and have a fresh new look at any sort of political motivation that may have been driving that initial request for a red notice from Lyon. So I think the reality is most people who are tax fugitives live their life in a tax haven and try and avoid going to places that they think they may get arrested. I had a client who spent years in Africa, was able to travel back and forth with different countries. Then as soon as he got on a Lufthansa plane, realized he was going to change planes in Frankfurt and knew as soon as the plane took off that was going to change his life. Now that was an antitrust extradition that he was focused on. But antitrust in a dual criminality situation had not been a crime in many of the European countries he went to When he landed in Germany, it was. And so he fought extradition all the way up to the German Supreme Court before he was able to come to the United States and resolve that matter. There were also tax issues with that because of the proceeds, right? The anti-money laundering pieces that could be part of any of those things. But all of those issues flow into kind of an overall analysis for the Justice Department of how aggressive or how interested they are in really trying to attack somebody on an extradition basis. So that's a quick rundown of how extradition works in the US, to the US, and from the US. Like some of the things that Kevin and Andrea were talking about, it's really fact specific. So you gotta dig into it in great detail, and there's opportunities to attack it throughout. Thank you.
Bill. And you know, we've gone beyond 1 o'clock. We do have a couple of questions. If you want to stay on, we'll be happy to try and address those. If you want to sign off, that's okay too. Here's a question about dealing with the FATCA IGAs. While Andrea discussed the types of IGAs, it is clear that the information the IRS requires from the foreign jurisdiction through the IGA is far greater than the information we provide under the IGA. So the question is, do you think the US will ever comply with Article 6 of the FATCA IGA Model 1A, which is where all the information the foreign government's sending automatically, are we going to reciprocate it? We're going to do the same amount. And it says that if the Model 1A became reciprocal in that way, it would be equivalent to the OECD's Common Reporting Standard. Well, the US is not a party to the Common Reporting Standard. I personally don't believe that the IGAs are going to change to make it that way. But, you know, the tides do turn. As you see now, we have the Corporate Transparency Act, that is our new law, that no doubt is tied to the various things that have happened with the Panama Papers, the Paradise Papers, BuzzFeed. When the authorities see the amount of wealth that's moving through the financial system, and a lot of it is tied to criminality, they want to be able to figure out who and what are behind all of these entities. And so the Common Reporting Standard will require all US entities, and that's defined right now as corporations and LLCs and similar entities. Trusts aren't included. There's a lot that still needs to be worked out, but basically all of those entities need to file forms with, it'll be, I think, Vincent, if I'm not mistaken, reporting who the owners are behind the entity and who the person is that filed the original formation document with the state authorities to create the entity. Moreover, one of the various measures that have come out under Biden's proposals would be almost the equivalent of a domestic FBAR, where US taxpayers have to report the information on all their US accounts. But, you know, we're not there yet. We don't know if we ever will be. There's another question, Andrea.
If I could just add one thing quickly to that too. When you're thinking about money moving internationally, the government is looking for that for a variety of reasons beyond just tax avoidance, right? The money that's moving and under analysis under Foreign Corrupt Practices Act efforts, under Anti-Human Trafficking Act efforts that different parts of the government are focused on, that information can be picked up, spotted, and flow over to the IRS. It doesn't really just have to be the IRS involved in these sorts of things. Law enforcement's generating hot leads all the time through very sophisticated efforts to investigate other things, often which have either bounty programs or cooperation credits, which are encouraging, you know, other people involved in the scheme to also call the IRS on.
Thank you, Bill. Great point. That really, the criminality function is really the key with the money movement oftentimes. Andrea, I don't know if you want to be able, if you can address this one. The name of the IRS campaign focused on cryptocurrency?
Yeah, it doesn't have a catchy name. It's just called virtual currency. You can plug in LBNI campaigns, and you'll get a whole list of them. So it's just called virtual currency. But maybe what they were asking about was, I had mentioned for the DOJ summons that there is this Operation Hidden Treasure, and that's kind of a collaboration between IRS-CI, the Criminal Investigation Division, and Fraud Enforcement Office. So I'm not sure if that helps. Hopefully it does.
The final question pertains to the John Doe summons that was issued to the law firm. And the individual is asking, doesn't the IRS have to have probable cause to pierce the attorney-client privilege? In truth, we'll get into this in greater detail in the fall. The cases that were cited by the government did not rely on the attorney-client privilege at all. It was relying on, I just forgot the code provision, but the CPA provision in the code that provides for confidentiality. The analysis was all on that. It did not get into the extent or depth of the attorney-client privilege. The dissent picked up on this. It's a miserable case. The analysis, personally, I think is flawed. It really does generate significant concerns as to the ability for the attorney-client privilege to remain if this case is not reversed by the Supreme Court, or if the IRS continues this way of looking in other jurisdictions, in other circuit courts, other courts of appeal, because this is a Fifth Circuit. But if they get it other places, it's the whole ball of wax. I mean, you can't hide behind anything. Now, again, the attorney-client privilege, and maybe Bill, you can get into it a little bit, isn't supposed to be used to hide from criminal activities. You can't use that as a sword. But notwithstanding, they shouldn't be able to get information from the law firm.
Yeah, well, that's exactly what I was going to say. What is often happens when a search warrant is executed at a law firm or a subpoena goes out to a law firm, the government's position is essentially to sort of wrap everything they take that afternoon, take it to the courthouse, have a taint team of agents who are not involved go through it to try and pull out things that are not privileged and present those to the judge to say, yes, you may look at documents 1 through 5,000, but not these 78 documents. Or the government will say, this is all part of the crime, and lawyers are not allowed to advise people how to commit crimes. The lawyers are a part of the criminal enterprise. And so the crime fraud exception, as it's referred to, allows the government, through the use of the courts, to pierce that attorney-client privilege because they're essentially saying that the lawyers were part of the scheme.
Bringing it back to this case in particular, crime fraud is not even referenced in the case. So it's a poorly reasoned case, according to me, and to many others who filed amicus briefs and the dissent. But thank you, everybody, for joining us. Thank you, Bill. Thank you, Andrea. And have a great day.